Hello, I'm very happy to be speaking here today. Thank you to all the organizers for the invitation. I'm going to pick up where Norman left off. He was talking about the issue of what kind of things can be patented. I'm going to turn more to the substantive issues, especially that of utility. The focus of today's discussion are both second use patents and also selection patents, where there's been a previous invention, that is, the compound is known, but has either a new use or an enhanced use. So, what is special about these types of patents is that it's not good enough just to claim the molecule, the compound, and say, here it is, it's useful, because the compound's already known, it already has a known use. So to be able to patent it, the very definition of invention here must be not only the compound, but its new use, either that it has a surprising, unexpected use or something of the kind. So we have to remember that general context when we're speaking about second use patents. So let me turn to the argument. We don't have much time. The first point is that, in fact, there is no international, whether formal or informal, standard regarding the content of the utility requirement, or in fact of the other requirements, either of novelty or of non-obviousness. In the first panel, we had some discussion about the existence of such a standard, and in fact, there's not even a standard that is common to the United States and Europe. Eli Lilly, in its arguments of the trade dispute, says, well, Canada ought to follow this standard, but it doesn't exist. And that's because the United States and Europe sit on opposite ends of a spectrum of what is expected in utility. The utility requirement in Europe is exceedingly low. You just have to be able to make it, whereas in the United States it has to be a credible, substantial, and significant utility. That doesn't mean a lot of things don't pass, but they are different standards, and there is really nothing that says that one or the other or some combination is correct. And this is very clear to any international patent expert. There are no international agreements that deal with this. In fact, there was an attempt through the World Intellectual Property Organization to agree upon the substantive content of patent laws. But this was shelved in 2006, largely because of the inability of the United States and Europe to agree on these standards. So when Eli Lilly says that there is some international standard, or at least there's the United States and European standard that's common, this is just clearly false. And it is so clear that this is wrong that that it's not possible that a competent tribunal that understands patent law could possibly rule in Eli's favor, even on this one point. And we saw during the first session how Eli Lilly was pushing the envelope on very significant rules of international trade law. But just in terms of patent law, this is an impossible argument. Second, there's an implied premise, in fact, I think it's pretty express, that there is something called a promise doctrine in Canadian law. And in fact, you'll never find such a promise doctrine. No court has ever called this a promise doctrine. In fact, promises is just another way of saying what is the utility that the patentee asserted, which is the common phraseology in the United States. We talk about assertions of utility. In Canada, we just happen, for historical reasons, to call it the promise instead of the assertion of utility. So there's no more a promise doctrine in Canada than there is an assertion of utility doctrine in the United States. And to argue otherwise just flies in the face of 200 years of case law where there is no separate promise from a general utility argument, and in fact, the more general arguments of novelty, utility, and non-obviousness often combined together. Eli Lilly, in its argument against Canada, brought forward a case, in fact, last year to the Canadian Supreme Court, and it set out 53 cases that it argued that between 2005 and 2013 involved a utility argument. And it argued that 17 of these 53 cases involved invalidity based on utility. Well, I've gone through all 53 cases, and this is just wrong. Uh, First of all, most of these cases, while many of them, even most of the 53, did involve a utility argument, it was not either the main basis or, in fact, the only basis for the ruling. That is, even without the utility argument, it would, to the extent that the patent was held invalid, it would still have been held invalid or not infringed, which comes to much the same thing in many of these cases. Second, many of these cases didn't even invoke a promise of a patent. They were decided on other grounds, such as the thing just didn't operate, just didn't even do anything. And so if we take out all of these extraneous cases, we're left with eight cases in which promise, in combination with the general utility analysis, became the reason for the invalidity. Out of those 8, only 7 were in pharmaceutical field. 1 had to do with helicopters. And only 2 of the remaining 7 pharma cases were actually in either infringement actions or impeachment actions. The other 5 were under what would be equivalent to the United States of the Hatch-Waxman Act. It wasn't a final decision on validity. It just simply allowed the generic to put a product on the market. It was still open in those 5 cases for the pharmaceutical company to bring an infringement action, in which case they could have argued that, in fact, the patent was valid. The only 2 cases in which invalidity was actually ruled upon in a pharma context both happened to be with Eli Lilly and are the subject matter of this dispute. So it's kind of hard to argue that 2 cases in the period of 2005 to 2013, and there are probably about 300 cases during that period, that 2 cases actually demonstrate a trend. It's very, very weak statistical evidence. The last point is that, contrary to what was stated in the first panel, the Supreme Court of Canada has never ruled on this issue. In fact, there's going to be a hearing in November where they will be asked to speak to the entire utility analysis, and at that point we may get some guidance. But to date, there has been none. Okay, so let's put all of that aside. And let's concentrate specifically on the utility standard that exists in Canada. Well, in fact, Canada has a fairly low utility standard. It sits somewhere between that of the United States and Europe. It's higher than Europe in the sense of it's not good enough that you just can make it. It has to be credible, but we do not require that the asserted utility have a specific and substantial utility as is required in U.S. law. In any event, the real question here is not what our utility standard is, that is, the Canadian utility standard is, and whether it's high or low, but how do we deal with a situation where a patentee, for strategic reasons, and by strategy here I mean they want to assure that the patent will be granted, and so they often assert a higher utility in order to meet the novelty or non-obviousness requirement. And we saw that for second use patents. This is required because just claiming the compound itself is not good enough. You have to claim the compound for some unexpected use. So it's that higher use that is claimed by the patent holder. What happens when the patentee makes this higher assertion but actually has no basis for it? And that's really where the entire discussion on promise comes in. So in Canada, we deal with it in the following manner. The court will will read the patent as a whole through the eyes of the posita, that is, the person skilled in the art, objectively. They will take into account whatever background knowledge this skilled person, the posita, will have, with an eye to finding the patent valid. So they'll ask, what did the patent holder or patent applicant claim based on what the posita would understand on an objective basis? So several places, Eli Lilly claims that Canadian patent law uses a subjective standard. I'm not sure where this comes from. We use the exact same standard as the United States does, that is, an objective standard using the person skilled in the art. If it is found that the patent holder asserted a higher utility than the law requires, then we will hold the patent holder to that asserted utility. That makes perfect sense. That is, if in order to gain patentability based on novelty or obviousness, the patent holder said, well, it actually has this higher utility, then we expect that the inventor actually had that. And so what we'll look for is either a demonstration that the patentee actually possessed the invention, that is, knew that this would happen, or that there was a good argument, credible argument, that this would be the case. So we'll look at the logic used to express the utility. Why does the patent holder think that it will work this way? And we'll look at whatever types of evidence they have to support it. So as long as the patent holder is able to provide a line of logic, and between the patent and general knowledge there's a logical and empirical basis, then the patent will be held valid, even if we haven't gone through clinical trials, which generally don't and is not required. The leading case of AZT, for example, was animal models, and an in vitro cells was sufficient. As long as the logic makes sense, that's fine. This is really not that different from the United States. I quote here from MPEP and from 1962 case, both of which said basically the same thing as the Canadian case. Now, this doesn't mean that there are no differences between the United States and Canada. In fact, the United States generally will enforce many of the asserted utilities higher than the minimum standard through enablement requirement for a variety of reasons. There are differences in terms of presumptions of validity and how that works out in practice. There are differences in terms of how we understand what a claim says through patent claim construction. There are different structures to the court system, so we do not use juries in patent cases, which obviously throws in a whole subjective element as in the United States. So there are different trial lengths and so on and so forth. So one would not expect necessarily the same decision in two countries. Also, the patents are often different, and often the Canadian case will happen after the US case, so there's some learning on the generic side, which gives them ability to muster evidence better. But the bottom line is that every jurisdiction, Europe, United States, Canada, in fact, every jurisdiction has to deal with the situation of a patent holder who asserts a higher utility for purely strategic reasons and fails to be able to either demonstrate that this is true or has a clear line of reasoning with some factual basis to get there. So we do it differently in Canada. The entire analysis tends to be done through a utility analysis rather than split out between enablement and utility, or in Europe between the technicality requirement and the inventive step requirement. But all patent systems deal with this in one way or another. That doesn't mean that Canadian patent law is perfect in any way, but neither, obviously, is the United States or Europe, and Norman gave us some reason to be critical of United States approaches. And so there's always room for improvement. But this is an internal discussion. But it's frankly impossible to say that Canada is out of line with a non-existent international standard. And once you get into the nitty-gritty of Canadian patent law, you realize that it's actually quite subtle. Only in the odd case, as I said, 2 cases since between 2005 and 2013, does it ever become critical. So thank you for hearing me today, and I would like to thank the organizations that funded my research: Genome Canada, Genome Prairie, Genome Quebec. This is all funded by peer-reviewed public granting agencies. So thank you very much.